on. No, that's on.
Oh, that's on.
That's on. Oh, green, red is on. Oh, top.
Push that one.
Talk and then.
Being present, the Subcommittee on Health, Employment, Labor, and Pensions will come to order. Good morning to each of you. Welcome to the first hearing of the HELP Subcommittee in the 115th Congress. Before I begin, I'd like to congratulate Ranking Member Sablan on his selection to serve as the Subcommittee's Senior Democrat. Welcome. I look forward to working together throughout the 115th Congress as we tackle the tough challenges facing our country. After years of struggling through an anemic economy, sluggish job growth, rising health care costs, and stagnant wages, the American people are expecting, in fact, they're demanding, a new direction for this country. They want policymakers to advance a bold, pro-growth agenda that will reduce the regulatory burden on small businesses, deliver a stronger, healthier economy, and provide hope and prosperity to families and future generations. The American people are looking for a better way, and this is precisely what this Congress, working with the new administration, is committed to delivering. Restoring balance and fairness to the National Labor Relations Board will play an important role in this effort. More than 80 years ago, President Franklin Delano Roosevelt signed the National Labor Relations Act to guarantee the right of workers to organize and collectively bargain over terms and conditions of employment, such as wages and benefits. Approximately 10 years later, Congress would reform the law to enact a basic set of protections for employers as well, such as the right to communicate with their workforce on employment and union-related matters. Together, both the original law and the subsequent amendments to the law are designed to provide a level playing field between employers and union leaders. But more importantly, they are designed to protect the right of workers to make free and informed decisions about whether they want to join a union. A neutral arbiter was created to maintain the balance Congress established in the law, protect worker free choice, and serve as an unbiased judge over labor disputes. The goal was to have an impartial referee who would apply the rules of the game fairly and objectively. The neutral arbiter was the National Labor Relations Board. although you wouldn't know it from the actions it has taken in recent years. We have repeatedly seen the Obama NLRB overturn long-standing labor policies and put in place new policies designed to empower special interests. It's why the board adopted an ambush election rule that chills employers' free choice and free speech, cripples worker free choice, and jeopardizes the privacy of workers and their families. It's why the board endorsed a new joint employer standard that will destroy jobs and make it harder for entrepreneurs and small businesses to pursue the American dream. It's also why the board is advancing a micro-union proposal that gerrymanders the workplace, thereby limiting the workplace mobility of employees and tying up employers in red tape. And it's also why the NLRB is expanding the power of union organizing on college campuses, whether it's organizing graduate students, student athletes, and others. This is by no means a comprehensive list of extreme partisan actions the NLRB has taken in recent years. As Republicans raise concerns with harmful consequences of these policies, our colleagues told us not to worry. These were all innocent changes that will improve the lives of working families. Meanwhile, workers have less time to make informed decisions in union elections. Micro-unions are being certified across the country, and small businesses, franchises, are uncertain about the future. None of this has helped invigorate the slowest economic recovery since the Great Depression. Small business owners and entrepreneurs deserve better. Workers and their families deserve better, and this Congress will demand better. In the weeks and months ahead, we will do everything we can to turn back this failed activist agenda and restore balance and fairness to the board. We will work to protect the rights of workers and employers and help create an environment where businesses can grow and all workers can achieve a lifetime of success. Again, I look forward to working with all my colleagues on this important effort. With that, I will now recognize Ranking Member Sablan for his opening remarks.
Thank you very much, Mr. Chairman. Let me also begin by congratulating you on your selection to be chairman of our subcommittee on health, employment, labor, and pensions. I'd also like to greet and welcome all our witnesses this morning. We'd be very much like to hear your point of views. This is my first meeting too as ranking member of this subcommittee. And I know that we have different personal backgrounds and experiences, and I know as chairman and ranking member, we are both expected to represent the views of our respective side of the aisles. But I hope that coming fresh to our jobs, as we both do, we may be able to be free from preconceptions. I hope we can remain willing to listen to each other and to the many points of views we will hear from other members and witnesses who will appear before this committee. I really do look forward to working with you. And as I see it, we have two choices in today's hearing and over the next 2 years as we examine the National Labor Relations Act. The purpose of the NLRA is to strengthen unions as an institution in our economy to ensure that wealth is more fairly shared. The preamble to the Act states, and I quote, "The inequality of bargaining power between employees who do not possess full freedom of association or actual liberty of contract and employers who are organized in the corporate or other forms of ownership associations substantially burdens and affects the flow of commerce and tends to aggravate recurrent business depressions by depressing wage rates and the purchasing power of wage earners in industry, and by preventing the stabilization of competitive wage rates and working conditions within and between industries," end quote. Here is the policy prescription set forth in the National Labor Relations Act. It is declared to be the policy of the United States to eliminate the causes of certain substantial obstructions to the free flow of commerce and to mitigate and eliminate these obstructions when they have occurred by encouraging the practice and procedure of collective bargaining and by protecting the exercise by workers of full freedom of association, self-organization, and designation of representatives of their own choosing for the purpose of negotiating the terms and conditions of their employment or other mutual aid or protection. Nothing harmful there. Now the question is, does this committee update the National Labor Relations Act so it can be more effective in implementing these goals? Or do we go back to the era prior to its enactment, 80 years ago, older than I am, and I'm an older man, and find ways to undermine its purposes? We have choices. We can address the needs of working Americans whose pay have been largely stagnant over the past several decades despite rising productivity. We can try to rebuild the middle class and those who want to climb the ladder to get there. This is particularly important following the hollowing out of so many good-paying jobs caused by the economic collapse of during the Great Recession. We can study the economic history of our country to assess how unions helped to make sure that growth in productivity rates was closely linked to growth in wage rates. When the economy grew after the Great Recession, data shows that most of the new wealth was funneled disproportionately to the 1%, while the benefits began to spread more widely in the past few years. One thing is unmistakable: far too many have been left behind. We know from studies that the decline in union density and collective bargaining coverage is closely associated with rise in income inequality. The median weekly income of full-time wage and salary workers who were union members in 2014 was $1,004, according to the U.S. Bureau of Labor Statistics. For non-union members, it was $802. Unionized workers also have more access to paid holidays, paid sick leave, life insurance, and medical and retirement benefits than those workers who are not unionized. At home in my district, in the Marianas, we don't have many unions, but I know that our unionized communication workers are earning about $3.50 above the minimum wage, which is $6.55 an hour, at the entry level, and 2 to 3 times as much as minimum at the higher levels. Another choice is to go down the same path we have been following for the past 3 sessions of Congress, when there have been 25 hearings and markups focused exclusively on weakening the National Labor Relations Act. Bills have been passed which give employers greater power to block union organizing efforts. Other bills actually block the ability of the National Labor Relations Board to function. When you consider that private sector unions represent a mere 6.4% of the workforce, it is troubling that the committee has directed so much time on this small independent agency. But attacks on the National Labor Relations Board are what they are, a proxy for attacks on unions. We would like to work with you, Mr. Chairman, to try to chart a new path. We have legislative ideas to improve the National Labor Relations Act, which are outlined in the Wage Act, and I would like to see if we can get this discussed in committee. I want to thank our witnesses for their work in preparing for today's hearing, and I look forward to hearing your testimony. And with that, Mr. Chairman, I yield back. Thank you very much.
I thank the gentleman. Pursuant to Committee Rule 7C, all members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. It's now my pleasure to introduce our distinguished panel of witnesses. First, Mr. Kurt G. Larkin is a partner of Hunton and Williams, LLP in Richmond, Virginia. Mr. Larkin advises businesses of all sizes on a host of traditional labor subjects, including union organizing campaigns, single and multi-employer collective bargaining, handling strikes and lockouts, and responding to and litigating unfair labor practice charges. He has advised clients in numerous union organizing campaigns, including under the NLRB's new representation case procedures, the ambush election rules, and helped clients prepare advanced strategies for responding to union organizing under the board's new rules. Welcome. Ms. Reem Alul is the owner of Bright Star Care of Arlington in Arlington, Virginia. After over 20 years of senior executive experience in management consulting, Ms. Alul decided to focus on helping people in her local community remain in the comfort of their homes. She founded Bright Star Care of Arlington and became a certified senior advisor in the field. She will testify on behalf of the Coalition to Save Local Businesses. Welcome. Ms. Susan Davis is a partner at Cohen, Weiss, and Simon of New York City. Ms. Davis specializes in the representation of national, regional, and local labor unions in all aspects of collective bargaining, litigation, mergers, affiliations, organizing, strategic planning, and internal union governance. Welcome. And finally, Mr. Raymond Lajeunesse is a vice president and legal director for the National Right to Work Legal Defense and Education Foundation, Incorporated in Springfield, Virginia. The foundation is a nonprofit, charitable organization that works on behalf of employees. Its mission is to eliminate compulsory unionism abuses through strategic litigation, public information, and education programs. Mr. Lajeunesse has extensive experience assisting employees with matters before the NLRB. I now ask our witnesses to stand and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? You may be seated. Let the record reflect the witnesses answered in the affirmative. Before I recognize you to provide your testimony, let me briefly explain our lighting system, which is not new to all of you. But you have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. Go. When the 1 minute is left, the yellow light will turn on. And then when the red light comes on, finish up your concluding thought as quickly as possible so that we have the opportunity for all testimony to be given and then the opportunity for questioning. So having said that, let me recognize Mr. Larin for your 5 minutes of testimony.
Thank you. Chairwoman Fox, Subcommittee Chairman Wahlberg, and Ranking Member Sablan, and members of the subcommittee. It's an honor to be here with you today to discuss the topic of restoring balance to the National Labor Relations Board. The NLRB has a long and distinguished history of administering our federal labor laws and regulating the conduct of labor management relations in the United States. Now, the board's primary obligation under the National Labor Relations Act are to oversee the formation of collective bargaining units and to investigate and remedy unfair labor practices committed by employers and labor organizations alike. In carrying out these duties, the board is generally expected to act as a neutral arbiter of facts and cases. Since the board is made up of political appointees, its interpretation and application of the policies underlying the act, its enforcement priorities, and its case precedents do tend to shift depending on which political party holds the majority. As a result, labor practitioners like myself have come to expect at least some changes when control of the board changes hands. Now, provided that its members and its general counsel confine their actions to the limitations of the act, the system remains workable, although sometimes unpredictable. Unfortunately, and in contrast to the modest and gradual changes we've seen back and forth over the years, the board over the past 8 years has produced some of the most drastic and one-sided policy changes in its history. And in almost every instance, these changes have worked substantial hardships on the business community. For example, the board has promulgated burdensome new election procedures that dramatically reduce the time employers have to respond to union organizing campaigns and which paralyze them with administrative tasks. It has established an obtuse new standard announced in the board's now infamous specialty healthcare decision for creating collective bargaining units that too easily allow unions to gerrymander the unit based only on the extent of organization. This standard has created the potential to balkanize an employer's workforce by dividing it into multiple units and paralyzing the employer with endless and competing negotiations. The board's also rewritten the rule book for determining whether a business is a joint employer of the employees of another business. I'm talking, of course, about Browning-Ferris. The test in that case overturns decades of settled law and allows for a joint employer finding if a business merely retains the right to affect the employment terms of another business's employees. The board has since sought to force that test on other industries, including the franchising industry, threatening what is arguably the nation's #1 engine for minority and small business growth. Finally, the board has waged an assault on an employer's right to maintain common-sense workplace policies, including confidentiality rules, employer arbitration programs, civility codes, and even rules that protect an employer's legal obligation to investigate and remediate complaints of workplace misconduct. These are just a few examples of the precedents the board has remade over the past 8 years. And the common theme in all of these cases is that the board's rationale for the change neglects to account for the realities of the American workplace and the challenges business owners of all sizes face in today's economy. The board's given little thought over the last decade to how its policies can hinder an employee's ability or employer's ability to run a business and maintain a productive workplace. So, while the ability to set the agenda may be the prerogative of those in control of the board, its actions over the past 8 years have turned the labor management landscape upside down. We're not asking the board to be pro-business. We're just asking that it not be anti-business. I respectfully submit that it's long past time to restore a sense of fairness and common sense at the NLRB. That starts with a re-examination of some of these precedents. Some changes may be made here in Congress. For example, there have been proposals to modify certain definitions in the Act and return the joint employer standard to that which existed prior to the board's recent decisions, and that would be a good start. But the board itself must undertake some of these changes. This can't take place, however, until it's fully constituted. Only 3 members are presently serving terms, leaving 2 seats open. In closing my remarks, I would just suggest that it's perhaps more imperative than ever that Congress and the President reconstitute the board to its full 5-member capacity so that it can begin to re-examine and hopefully restore its precedence to a state that more meaningfully accounts for the realities of the American workplace. Thank you again for the privilege of testifying today.
Thank you. And I recognize Ms. Alul for your 5 minutes of
Thank you, sir.
testimony.
Chairman Fumin-Fex, Chairman Wahlberg, Ranking Member Sablin, and distinguished members of the committee. My name is Reem. I own a Bright Star Home Care franchise in Arlington, Virginia. I thank you for the opportunity to appear before the subcommittee today. While there are many issues before the National Labor Relations Board, the NLRB, that should be discussed, I'll focus my remarks today on how the NLRB changed the fundamental definition of employer and how that is directly affecting locally owned businesses like mine. I appear before you today on behalf of the Coalition to Save Local Businesses, a diverse group of locally owned, independent, small businesses, associations, organizations that is working to restore the common sense traditional definition of joint employer. Mr. Chairman, my path to entrepreneurship started in Jordan, where I was born. My father was also an entrepreneur. Like I would many years later, he left a comfortable job to make it on his own and provide a better life for my mom and 3 siblings. My mom stayed at home, cared for all 4 of us, and I finished high school in Jordan, went to the American University in Cairo for a degree in economics. I've been living in Arlington, Virginia since 2004, and I'm pretty sure I got my entrepreneurial bug from my dad. I've traveled the world before starting my business, supporting businesses and governments around the world to improve their operations and service delivery. In 2013, as many entrepreneurs before and after me have done, I've made the bold, risky decision to quit my job and pursue my dream of opening a business, of owning my own business. I decided to serve my own local community, and risked all of that. And my risk has paid off for my community because my company is in its 4th year of operation, and I today have about 90 employees on our books. I established my business with 2 main goals: provide peace of mind for clients and their families as they age at home, and provide job opportunities for people in my community. We find ourselves providing jobs to people who may need more flexibility to be able to succeed. We employ single moms, military spouses, students, and those who care for their own families as well. We're as flexible as we need to with their unique schedules, and they seem to greatly appreciate that. Independent monthly employee satisfaction surveys show on average that we have a 92% satisfaction in the last 16 months. The decision by government officials here in Washington to change the joint employer standard is baffling one, frankly, for me. The new employer standard created by the NLRB back in August 2015 is based on indirect control and even reserved, unexercised control. The policy is so broad, so unpredictable, it could be practically applied to anything in terms of business relations. Mr. Chairman, you cannot overstate the confusion caused by unlimited joint employer liability. Under this policy, it's a wonder why franchisors provide any support to franchisees because of fear of joint employment lawsuits. Fortunately, I've partnered with a wonderful franchisor, Brightstar out of Illinois. The company provides franchisees with a technology platform for billing, payroll, quality assurance, and things like that. Such resources are a big reason why entrepreneurs opt for a franchise model as opposed to their own standalone business. But now with the new joint employer standard is based on indirect and unexercised control, why would franchisors continue to provide such resources? Out of fear of liability risk, they'll stop supporting franchisees or maybe even regain that power over these businesses. Either way, small businesses lose. This is a small business issue. I presume you all want to support small businesses. Big corporations, after all, have resources, attorneys, economies of scale to adapt to joint employer. It's the small employers like myself who may run out of business partners because of this. Joint employer eventually will mean more corporations and fewer small businesses on Main Street. As a franchisee, one of many, I believe that the joint employer unfairly changes the rules of business in the middle of the game. I invested a career's worth of savings in this business, and now joint employer liability threatens everything I and many other than me have worked for. We need Congress to enact legislation that clears up the basic question of what is an employer. It can't be ambiguous. It can't be left to federal administrations changing it one after the other. Every member should think what they're doing for small businesses. Many politicians today are making it harder to start a business, harder to thrive as an entrepreneur, and we need your help to make it clear. What does an employer mean? The joint employer standard doesn't make any sense. It makes it harder for entrepreneurs, for clients, for businesses, for employees, and the government itself as well. I'm in the business of making the tough times in life a little better for people. I'm here today asking Congress to make the lives of small business owners a little easier, a little more certain, providing a fair legislative fix to harmful joint employer standard. To conclude, Mr. Chairman, this subcommittee also received a letter from several dozen employer and franchisee associations explaining further this issue. I commend this letter to you. I thank you, Mr. Chairman, for your work on behalf of the locally owned businesses everywhere, and I would be more than happy to take any questions anybody may have.
Thank you, Ms. Alul. Now I recognize Ms. Davis for your testimony.
Good morning, and thank you, Chairman Wahlberg, Ranking Member Sablan, and distinguished members of this subcommittee. Thank you for inviting me here today to respond to what I believe has been a bit of overheated rhetoric about what the Obama board has done. During the past 35 years, I've practiced before the Reagan board, the Bush board, the Clinton board, and the Obama board. While that makes me feel a bit old, it also makes me feel well-equipped to address what I believe is a misnomer. The board does not need a recalibration or a realignment or a restoration of balance and fairness. As Mr. Larkin noted, the Democratic and Republican boards have differed on their view of the statute, on whether, as the chairman stated, it is a neutral act, or whether, as the preamble states, it's an act designed to promote collective bargaining. But regardless of our individual views, the Obama board's view of the statute was rooted in the statute itself. When the rhetoric is swept aside and the temperature is taken down a bit, which I think is a good idea, the 4 flashpoints that brought us here are pretty uneventful. The board did modernize the election rules to make modest and meaningful changes to the procedures. But when you look at the statistics, the number of cases in which the parties actually are able to agree to stipulate to an election without a hearing, which is 92%, and the union's win rate, which is in the mid-60s, those statistics have not changed at all before or after the rules. Yes, the board did clarify the standard it would apply in analyzing appropriate bargaining units. But that decision came squarely out of the D.C. Circuit Court of Appeals analysis in the Blue Man Group Vegas case, a 3-Republican appointee panel, and 7 courts of appeals have affirmed the board's analysis. Additionally, in spite of the specter of the proliferation of micro units, which, Mr. Chairman, you alluded to, the median unit before, now, during, after specialty, about 26 people, is identical to the median unit in the decade prior to specialty health. Yes, in BFI, the board did apply a common law agency test for analyzing joint employer. That's the same test the board applied for 50 years prior to the narrowing of the doctrine under the Reagan and Bush boards. This decision, like many others the Obama board issue, was designed to make the act relevant in the modern workplace, where we have seen employers continue to shed the employer-employee relationship in order to minimize or negate liability. And we've seen an explosion of permatemps who work side by side with workers and deserve protection as well. The McDonald's complaint, which has caused such a hue and cry, was issued prior to BFI under the old standard. And let's remember, McDonald's is only a complaint. There's been no LJ decision. There's been no board decision. We need to let the process run. It bears noting that the General Counsel in the 2015 Freshies franchisor decision, I would commend everyone in this room read that, found that because the franchisor's control was limited to brand standards and food quality and the sorts of technology platforms that Ms. Alul mentioned, and not to the employer-employee relationships, there was no joint employer liability. If a franchisor is currently exercising or reserving contractual authority over labor relations of its franchisees, the solution is simple. It can eliminate its liability by reducing that control. And if it chooses not to do that, there is now some congruity between a franchisor's responsibility and its liability. Finally, the Obama board did decide that requiring employees to sign class action waivers violated the NLRA. The NLRA is the only statute in this country that protects collective rights. And while that is a little more difficult for some to digest, it does protect those rights. More than 40 years ago, the Supreme Court in the East Tex case told us that employees' rights to join together to sue over terms and conditions of employment was protected. And the Supreme Court has said multiple times that an employer may not condition employment on waiving statutory rights. Murphy Oil involves no more than that. In closing, I'd like to say the following. I fear that the call to restore balance and order and fairness on the NLRB is a euphemism for restoring a labor law regime that delegitimizes unions and prevents workers from having a collective voice at work. I heard the same cry for a restoration of balance after the Clinton board. It is, I believe, a code for a board that will weaken labor unions and disempower workers. History shows us that when unions are weakened, income inequality, which is at an all-time high right now, increases. Let us remember that President Trump campaigned on the promise of helping American workers on addressing decades of wage stagnation. Weakening the board and thereby weakening labor unions will only make that problem worse. Thank you, Mr. Chairman.
Thank you. And now I recognize Mr. Lajeunesse for your 5 minutes.
Chairwoman Fox, Chairman Wahlberg, and distinguished committee members. Unfortunately, the National Labor Relations Board majorities President Obama has appointed have often denied or diminished the rights of workers to refrain from union associations, rights that are guaranteed by Section 7 of the Act. In states without a right to work law, one of the most important rights that workers have is the right not to pay the part of union fees that represents the cost of political and other non-bargaining activity. That right was recognized in Communications Workers versus Beck. In Beck, the Supreme Court affirmed a Fourth Circuit decision that under the NLRA, objecting non-members cannot be charged a union for a union's labor legislation expenditures. Moreover, in Machinist versus Street, which Beck found controlling under the National Labor Relations Act, the court had held that the Railway Labor Act does not authorize union officials to use objecting employees' exacted funds to support, quote, the promotion or defeat of legislation. Yet, in United Nurses and Allied Professionals, the Obama board held that lobbying used, quote, used to pursue goals that are germane to collective bargaining, contract administration, or grievance adjustment is chargeable to objectors. United Nurses exemplifies another way in which the Obama board has eviscerated non-members' right not to pay for union non-bargaining activities. In Teachers Local 1V Hudson, the Supreme Court held that potential objectors must be given sufficient information to gauge the propriety of the union's fee, including, quote, verification by an independent auditor, unquote. Yet, in United Nurses, the Obama board ruled that a union need not provide objectors with an auditor's verification. The board majority argued that unions' conduct under Beck need not be analyzed under a heightened First Amendment standard, as in public sector cases such as Hudson. However, the D.C. Circuit had already explicitly rejected that argument in 2 cases in which it reversed the board. The Obama board also has applied a lenient standard to the common union requirement that objections to subsidizing union non-bargaining activities be renewed annually during a short window period. After 3 federal courts ruled that workers should be free to make objections that continue in effect until withdrawn, the Obama board did not hold annual objection requirements per se unlawful as the courts did. Instead, the board decided to evaluate those requirements on a union-by-union basis to determine whether the union has a legitimate justification. Applying that loose standard, the Obama board upheld the United Auto Workers annual objection requirement without even considering the union's justifications, finding that the burden on non-members was de minimis. As the dissent said, the burden is plainly and decidedly not de minimis because objecting entails time and cost, and if non-members, quote, fail to timely renew their objection, they will automatically incur the obligation of paying a full agency fee, including funds for expenditures for non-representational purposes. The Obama board also has repeatedly undermined the right to refrain from union representation that NLRA Section 7 guarantees equally with the right to organize. A union may become an exclusive representative of all employees in an appropriate bargaining unit, either by winning a board-conducted secret ballot election or obtaining the employer's recognition based on a union showing of majority support on cards or a petition. Either way, this creates a monopoly. As the Supreme Court has held, exclusive representation extinguishes the individual employee's power to order his own relations with his employer. Employees can petition for an election to decertify a bargaining agent chosen by election, but not within 1 year after that election. That statutory bar does not apply to voluntary recognition, and the board then created, it's not in the statute, a bar to decertification elections after voluntary recognition, and created a contract bar which can, and additionally, almost 3-year period, up to a 3-year period, no decertification election can be held. In 2007, in Dana Corporation, the board created a procedure by which employees could decertify after a voluntary recognition, but the Obama board, despite the fact that in the almost 4 years that followed Dana, the union recognized by the employer based on union authorization cards without a secret ballot election was rejected by the employees in 1 out of every 4 Dana elections. The Obama board in Le Mans Gasket overruled Dana 3-1, incredibly asserting that Dana's ruling undermined employees' free choice. Other issues which adversely affect employees are the ambush elections and the gerrymandering of bargaining units under specialty health care, both of which result in denying employees their right to be free from union association. I've recommended in my prepared remarks, submitted the written statement presented to the committee, several matters that the House can undertake and to solve these problems, but the most important one is the one that's already been mentioned, which is the board needs to be filled. We need 5 members on the board to return us to sanity in the discussion of labor issues, to return to employees
I thank the gentleman,
full
but your
rights.
time has expired, and we certainly appreciate the written testimony. I now begin the questioning by recognizing the chairman of the full committee, Ms. Fox, for her 5 minutes.
Thank you very much, Mr. Chairman, and I want to thank all of our witnesses for being here today and sharing their expertise with us. Ms. Alul, can employees effectively negotiate with a franchisee over their wages, hours, or other conditions of employment without the franchisor? And how would the inclusion of the franchisor affect the negotiating process?
Thank you for your question, Madam Chairwoman. They absolutely can do that, and this is what we do today. We decide based on market demand what jobs are needed and how many openings do we have. We post for them, we negotiate rates, we do raises, we do performance evaluations, and we do the direct placement of our employees with our clients on a day-to-day basis. We know where they live, we know their schedules, we know who has family issues and we need to work around their schedule. And it's definitely much harder, much slower, not good for the employees, and will absolutely affect quality and price for clients if it was done differently, ma'am.
Thank you very much. Mr. Larkin, on average, how many elections are appealed to the board post-election? In your experience, are these appeals based on minor issues, and how have the ambush election rules changed this process?
I couldn't give you the exact number as a percentage of cases that are appealed to the board post-election. What I can tell you in my practice is that when one side or the other loses a close election, they often raise objections to the conduct of the election and seek review of the result with the board. That part of the process hasn't really changed much under the new rules, but what they have done is that they've deferred until after the election the ability to get answers to some very important questions. I'll give you an example. Under the old rules, if an employer thought that a proposed bargaining unit included supervisors, the employer could raise that issue with the regional director, and if agreement couldn't be reached between the parties and the regional director on the answer to the question, there'd be a hearing. And the regional director would take evidence and issue a ruling as to whether the employee in question is a supervisor. The reason it's so important to know the answer to a question like that in advance is that you know how to treat that person during the election campaign. If someone's a supervisor, you can communicate as the employer to the rest of the workforce through that individual. If they're not, they're a voter, they have Section 7 rights that have to be acknowledged under the new rule. And so the point being that if you treat that person as a supervisor and you're wrong, you're violating the law. Under the new rules, you don't get an answer to that question up front. You basically have to roll the dice and take a guess as to whether you're right or wrong. So that's just one example of the ways that the change in the rules have frustrated my client's ability to be effective in campaigns, and something like that could certainly lead to a post-election challenge.
Thank you very much. Mr. Lajeunesse, you look like you wanted to respond to that a little bit, and you're welcome to do it, but in your experience, when a majority of employees no longer support a union, how are they able to easily get rid of it? And do the administrative procedures and red tape often frustrate them to the point that they consider giving up on the effort to get rid of the union?
I think the short answer to your last question is yes. The new rules for representation elections, which also apply to decertification elections, are massive, very complex. And workers are not lawyers. And to work their way through that in the short period of time allowed under the new rules, the ambush election rules, it's not only the problem of the complexity, but it's also the problem in that short period of time. How does the average worker who's up against the professional union organizer organize and sell his point of view to his fellow employees? At the same time, he's got to find a lawyer to help him work his way through what the dissenters when the rules were adopted called a Mount Everest of regulations. And I would add on the point with regard to I'm sorry, I lost my...
The previous, okay, thank you very much.
Thanks, gentlelady. Now I recognize the ranking member, Mr. Sablan.
Thank you very much, Mr. Chairman. Ms. Davis, in 2015, the National Labor Relations Board General Counsel issued an advice memorandum determining to find a joint employer relationship between Freshie, a food franchisor with over 100 stores in a dozen countries, and its franchisee in Illinois, because the franchisor's control was limited to brand standards and food quality. Can you explain the significance of this advice memorandum, particularly since it has been overlooked by many commentators who contend that the National Labor Relations Board is arbitrarily deeming franchisors and franchisees as joint employers?
Yes, thank you. The Freshies case, which really I commend to everyone to read, it is an advice memorandum. It indicates how the General Counsel will view cases, what it will prosecute and what it will not prosecute. And in the Freshies case, even though there was extensive technological support to the franchisees, the type of support that Ms. Alul correctly said is so necessary, because there was not franchisor control over labor relations, over what employees were paid, what they were not paid, what their schedules were, the General Counsel declined to prosecute and find a joint employer relationship. So I suggest what Freshies should tell all of us is to keep our powder a bit dry on how big this problem is till we see what actually takes place as this doctrine evolves.
All right, thank you. Ms. Alul, let me, Chairwoman Fox asked you a question, and I'm not sure that you answered them, but let me try in my own way. Tell me about your franchise agreement with your franchisor. Does this legal agreement dictate how much you should pay employees, or what schedules to set up for your employees, or set your disciplinary practices? Is that up to you, or does the franchise agreement set the terms and conditions for these arrangements with your employees?
Thank you for the question, sir. No, it does not. My franchise agreement does not talk about how we hire people, what we pay them, what kind of disciplinary action we do, none of that. So my short answer for you, sir, is no.
Okay.
But the issue is really when there's ambiguity in the law, it is very difficult for small business owners like myself to manage that. When the language says indirect, reserved, unexercised control, it makes it very difficult for people like me to interpret that. To be frank with you, when I hear language like that, it tells me that the government is telling me I reserve the right to do whatever I want to do with you at some stage in the future.
All right, so let me ask you, does your franchisor, Bright Star Care, come to your workplace and directly supervise the employees you hire for home care?
They do not.
They do not.
They do visits for general quality assurance, for brand standards, but not related to how we hire and manage people. No, sir.
Let me ask you another question. Does the franchisor tell you what to do if there is a union organizing effort, or is that up to you?
That is up to me.
That is up to you. So it sounds to me like you're managing employee relations as you deem appropriate, and that employee policies are yours to determine as the owner. Given that, can you explain how the BFI decision could impact your business?
Absolutely. Again, going back to unclear, ambiguous language, this is the enemy of business. When my franchisor hears such language, they are, rightly so, frankly, they're scared of lawsuits, of joint employment lawsuits. Based on that, and again, given the fact that the language says indirect unexercised.
Who's they? Wait, I'm asking you, because you're managing your employees, so you said they are worried about, who's they?
They, as the franchisor.
So,
I am in a
so that's my
contractual
question.
agreement.
So your franchisor may actually also be managing your employees, right? Because
No.
they're
No,
working
but the
through
business
you.
relationship includes way
Through
more than
you.
just managing employees. The business relationship includes quality standards, includes.
I understand that, but they come and tell you on how to address your employee-employer relationship.
They don't.
They don't, but yet they do, in somehow. Am I correct?
No, you're not. I'm sorry, you're not.
But you're using the word they. See, come to you. They are worried about this. They are worried about
They're
that.
worried about the lack of clarity in the law, which affects the business
About your relationship with your employee.
No.
Thank you. My time's up, Mr. Chairman.
Gentleman's time has expired. I recognize myself for 5 minutes of questioning. Ms. Alul, does operating your business in Northern Virginia create any specific challenges or opportunities that franchisees in other places might not experience?
Absolutely. When you decide to open your own business, you've got two paths to choose from. One is start your own business, standalone, Ream and Associates, and the other one is to opt for a franchise model. People like me opt to go for a franchise model because you don't want to start from scratch. You want to be part of that community, the best practice, the support like the technology platform that I mentioned in my testimony. So when in the future, this interpretation of the NLRB for the new joint employer standard, it makes it less clear for people like me to know how much control am I going to have in my business. Is this going to scare my franchisor so that they want more control in my business? I don't want that. Is it going to scare them the other way around to say, you know what, we've got nothing to do with you, you're on your own, you have no support from us at all? That scares me as well, because I signed a franchise agreement in 2013. That is a 10-year agreement, and this changes the rules in the middle of the game. I need the support, and it's what encourages people like me to go into business and own their own.
So everything for your 90 employees, am I correct, 90?
That is correct.
90 employees becomes tentative as well.
Yes. The 90 employees are ours. They have nothing to do with the franchisor. We employ them, we place them, we train them, we promote them.
Okay, thank you. I think that clarifies a bit the challenges in running a business to benefit both your clients at specific times in their life that need help, but also the employee to know and understand what type of arrangement they are in and that they can go directly to you.
Absolutely.
Yes.
So if I may add something, when you run a small business, you're it. I visit with my clients myself. I give them my business card and it has my cell phone number at the back of it. I do that with my employees as well. They have access to me 24 hours a day, 7 days a week. If they need to deal with a franchisor out of somewhere far away, they don't have that. It overcomplicates the process, quality will be lower, cost. Everybody in this room is going to need home care at one day or another. Some of us will need it in the next year or two, others in a couple of decades, but we all will. And when we do that, we need the service to be the best it can, the least expensive it can, and you want to be able to deal with somebody locally. You don't want to deal with you don't want to deal with a large corporation somewhere in the middle of the country. You want a local office here.
Appreciate that. Thank you. Mr. Larkin, are employer concerns about the ambush rule or micro-unions based entirely on wanting to avoid a union, or are there other concerns such as proper conduct during representation elections, employers knowing the right way and employees knowing the right way to deal with? What are some of those challenges?
Well, I can only speak for myself and not any employer, but the vast majority of my clients don't enter into a particular business proposition, whether it's a franchise or franchisee proposition, a contractor, subcontractor proposition, to avoid unionization. They enter into the business proposition because they think it's good business. And so I think that the problem with the joint employer standard, Ms. Alul has so eloquently articulated it, is that the uncertainty in the standard as to whether it's going to apply to you or not, based on the facts of your case, has caused many of these business models to be threatened because, as she just said, she doesn't know the answer with the retained and the indirect control elements. And you know, I will add that, you know, when I advise my clients, under the old standard, it was fairly straightforward. If you exercise direct or immediate control over your business partner, whatever the partnership might be, you're probably going to be a joint employer. Okay. And so it was relatively predictable for the business to set up whether they wanted to be one or not. Under this new standard, there is no predictability to the standard, and it's much more difficult, and just you're sort of crystal balling what the answer is going to be. I certainly don't like to do that as a lawyer and tell a client I don't know the answer, but unfortunately that's the answer that we give more often than not. If I could, I'd like to just.
My time has expired, and we may get back to that. I now recognize the gentleman from New Jersey, Mr. Norcross, a fellow Harley rider.
Absolutely. Chairman, congratulations. It's good to be here, and certainly to hear some of the testimony today, and it seems like I'm in an alternative universe. The NLRB changes that I want to focus on have to do more with the election. We're in much more modern times than we were a quarter century ago. Instant news. I guess President Trump really showed that things happen at a very quick pace. And the election rules, from everything that we've heard, are not burdensome, are, quite frankly, easier to deal with. And so as I try to develop a question, that's why I think I'm in a different universe. I want to read you some statistics. Since the second term of Bush, the percentage of unionized employees in this country went down 1 year, went up the next 2 years, and remained stagnant for the following year. Every year since the Obama administration, with the rules that you're condemning, union percentage went down. Let me repeat that. Union percentage went down, even though you're saying these rules are absolutely against the employer. The one thing I do understand, it's a partnership that we work together. Some of the comments I hear really concern me because most people understand that, with very few exceptions, that they just want to have a voice. And I guess what we're having a discussion today is, are you going to let your employees have a voice? Are you going to share, in some small measure, the profits that that company was able to earn because of both management and labor? Now, we're having a discussion here how this controversy, and we're always going head to head. Here, the percentages aren't lying. The election rule that you spoke about, the ambush election, it's horrible one side, but you mentioned that when you desert, you want the rules to change. So it can't be both ways. So I guess my question comes down to, when we look over the course of the last 25 years with the changes and the downward trend of unionization, number one, we have some really good lawyers on the other side who know how to stretch it out, because it's not just about getting the election won. It's actually getting a contract. The election is very short. The fact of the matter is, you talked about the supervisor. It's called a provisional ballot. It's what we do every day, every November. If you're not sure if you're going to vote or not, you vote and it goes into a special. the provisions set up for there. So, Ms. Davis, we spend a lot of time with folks who want to have a voice and just have a chance to take care of their family. We've seen the disparity in wages over that very same time with the decline of unionization. The disparity between those who make the most and the least grows wider. What's the number one issue you hear from those who want to join a union with all these rules?
Well, let me bifurcate your question and tell you first of all, I share your frustration about living in an alternate universe. I think the one thing I hope everybody in this room can agree on is that facts matter, actual facts. And the facts, as you said, show a decline in union density, notwithstanding the rules. The panoply of things that employers can do legally under the Act to prevent a union, one-on-one meetings with employees, captive audience meeting with employees, a constant barrage from the day someone is hired, precluding them, telling them it's bad for them to join a union. Those are all still there. They can completely avail themselves of that arsenal. Nothing was taken away in the election rules. The only thing that was taken away in the election rules was the pre-existing universe where any employer that wanted to delay an election from taking place could do it.
And that, quite frankly, was the strategy.
Correct.
Delay, delay, delay.
Correct. I've sat in 3-month hearings on supervisory status, where at the end of the day, the union was worn down. All these rules were intended to do was to allow the employees, in the month that the employer has the opportunity still to campaign against them, to decide on their own whether they wanted a collective voice in the workplace.
My time's about to run up, but in the years since the rule went into effect, unionization went down again. So I think instead of trying to divide folks, we should be focused on how we can work together. So not only the employer makes a healthy profit, but the employee share in that, and we both win. I yield back the balance of my time.
Thank the gentleman. His time has expired. I now recognize the gentleman from Tennessee, Dr. Rowe.
Thank you very much. And Mr. Larkin made the comment to begin with that he felt like the NLRB, as I do, should be a fair arbiter of the facts. And I know I played some basketball along the way. When the ball bounced off the other guy, I expected my team to get the ball. What's happening is when the ball bounces off the other guy, the other team is getting the ball. And I am a small business owner, and Ms. Alul, you pointed out very clearly the uncertainty that creates issues and problems. And what Ms. Davis mentioned was, we'll let this litigate and play out. We don't have in my business a legal department, and we don't have hundreds of thousands of dollars and millions of dollars to litigate these things. Maybe big businesses do, but small businesses don't. I think that one of the reasons that President Trump got elected was he spoke to people in the country who wanted to get this economy going and get jobs started. And I looked at the last 30 years. In the recession of 1992 to 96 during President Clinton, that recovery from that election, 420,000 new businesses were formed. And between 2002 and 2006, President Bush, there was a recession prior to that, 400,000 businesses were formed. Between 2010 and 2014, 167,000 businesses were formed in this country. That's millions of jobs that never got formed. And what's even worse, in rural America where I live, 20 counties out of 3,000 accounted for half the new business formation in this country. And what we have to do is let entrepreneurs and business people form. And this uncertainty, Ms. Alul, you pointed out, is part of it. Mr. Larkin, I want to have you to explain to me, what is the advantage? Why did that we go to an ambush, so-called ambush election, and reduce the time for unionization? And I grew up in a union household, full disclosure. What was the point of that? I think that was a solution looking for a problem.
I agree with that sentiment. Let me start by saying this. The declining overall rate of unionization in the United States, in my opinion, has nothing to do with the representation case rules. And I'm not here to give you an editorial on why that number is what it is. What I can tell you is that the win rate in representation cases that take place for unions has been above 60%, and in some cases, in this past year, it's 70%. So, as you say, sir, changing those rules was a solution looking for a problem. The rules were working fine for unions. So that's that point. The other point that I would make is, you asked, why were these rules passed? Well, one of the board members who was seated on the board when these rules were originally being conceived had written prior to becoming a board member about how, in his view, employers should have no right to communicate with their employees about unionization. There is a part of the National Labor Relations Act, Section 8C, that gives employers a free speech right to communicate with their employees. And so things like one-on-one meetings and captive audience meetings, that's called free speech. At least one of the members behind passing these rules doesn't believe that employers should have free speech. And one of the things that the rules do is it severely impinges on the time within which an employer can communicate with its employees about unionization. So if you ask me, that's one of the reasons, at least, why the rules were passed, to clamp down on the opportunity for employers to communicate with their employees about the union question.
I know that in my business, it would be hard for me to find a qualified labor lawyer like yourself in that length of time to educate myself. And you pointed out, you might be breaking a law you didn't even know you were breaking if you can't identify who it is, and you wouldn't do it on purpose, but you did break the law. What, Mr. Larkin, prior to the ambush rule, in your experience, what was the average time between a petition and representation election? How long?
The median time was about 38 days, and it's dropped somewhere 22 to 23. So that's a pretty precipitous drop in a year and a half.
And so, I mean, what is the advantage of that? In other words, where I don't have time to educate myself, my employees don't have time to educate themselves, who benefits from that? Less education, less knowledge about what you're doing.
I can tell you who does not benefit from that is the workforce and the employees who are the ones making the vote. And this is not in any way a judgment on the pros or cons of unionization at all. This is just asking for a fair playing field. Unions can organize employees in secret, and the employer may have no idea that a union's communicating with its employees about the pros of unionization. So it never has an opportunity to talk about its position and whether it thinks that there are other parts of the argument that employees should consider. That's the problem with these rules. It even further shrinks that opportunity for an employer to have that communication.
I yield back, Mr. Chairman.
Thank the gentleman. Now I recognize the gentleman from Connecticut, Mr. Courtney.
Thank you, Mr. Wahlberg. And at the outset, first of all, I heard my good friend, Dr. Rowe, mention a basketball analogy. I have to mention that the UConn women won their 100th straight victory last night. And
I yield.
Coming from Tennessee, that is quite, impressive.
And Mr. Chairman, the Gamecocks join in. Congratulations.
Thank you, Mr.
Lady Gamecocks, all right?
That's bipartisanship. We appreciate it.
So as long as we're on the subject of a solution in search of a problem, in January, just a few days ago, the Bureau of Labor Statistics again gave their most recent report on the percentage of unionized employees in the American economy. Once again, it continues on a downward trend, significant downward trend. The total number is 10.6%, and in the private sector, it's 6.4%. That has been a steady trajectory all the way since 2008. And again, Mr. Wahlberg is a good friend, but the narrative that started this hearing, which is that somehow these unionization rules are somehow acting as a drag on the U.S. economy. I mean, at some point, people have to sort of come up with empirical, economic data that actually demonstrates that there's some spike that these rules have created that somehow would impact hiring decisions. But in fact, what we're seeing is a steady decline. And really, at some point, you have to look at this from a macro standpoint to justify the Congress going in and trying to, again, somehow, as I said, find a solution in search of a problem. The specialty healthcare rule, which again, we've had a number of hearings already in the last few years on this, is another example of where, we need to get data to sort of understand whether or not the micro bargaining units is really causing some kind of, outcome here where we're seeing a proliferation of small bargaining units. Ms. Davis, your testimony actually had some data on that, and I was wondering if you could just sort of walk through what we're actually seeing in the wake of that 2011 decision.
Certainly. The statistics are kept by the NLRB. They're available on its website. And there's a study from fiscal year 2007 through fiscal year 2016, the median bargaining unit has bounced between 26, 25, 27. It is currently 26. So there is, again, I mean, I would urge everybody to look at facts, real facts. There is absolutely no data whatsoever that supports the notion that there is a proliferation of microunits. In the recent Volkswagen decision that has, again, caused such hysteria, the unit that was organized was over 150 employees. That is more than 7 times the size of the average unit. So I would suggest, again, that we need to look at facts and not just look at anticipatory anxiety of what might happen.
And that unit actually had a common purpose, which is it was a maintenance unit. I mean, they had a specific function that created a logic to the appropriate recognition by the NLRB. Is that correct?
That's absolutely correct. And for the past 50 years, the NLRB, before these rules, before specialty, has treated skilled units, such as maintenance units, as presumptively appropriate. So all it was doing is following the rules that have followed for decades in that.
And in my district, in Groton, Connecticut, where we have Electric Boat Shipyard, which has about 4,000 shipyard workers that are on the waterfront, again, they have metal trades units, carpenters, electricians, teamsters, machinists. Again, they come together with a Metal Trades Council in terms of collective bargaining. But again, there are specific reasons why this goes back to the 30s in terms of when those units were recognized. There is nothing inherently obstructionist or negative about the fact that you recognize that there are skills that really create a logic for separate units. Isn't that correct?
That's totally correct. And if I may, on your larger point where you started, which I think was the point to start, if you look at every period since 1960, when union density has increased, wage stagnation has increased. When union density has declined, income inequality has increased. So if you're looking at what's good for this country, what's good for Americans, there is no doubt that unionization has brought up wages, has increased people having pensions. If you do a comparison between right-to-work states, Mr. LaJeunesse talked about the right-to-work statute, and non-right-to-work states, wages are on average $6,000 per worker higher in non-right-to-work states. They have health care 75% of the time. They have pension more of the time. And if we're talking about what is good for that country, it seems to me to be something very basic that we all should be able to agree to.
Thank you. Mr. Chairman, I would like to enter the Bureau of Labor Statistics report from January 26, 2017 with the data that I just mentioned.
Without objection, will be entered. Hearing no objection.
I yield back.
I thank the gentleman, and now I recognize the gentleman just joining our subcommittee from Minnesota, Mr. Lewis. Welcome.
Thank you, Mr. Chairman, and thank you to all of the witnesses here today. Certainly, data and facts do matter, and I think if we look in a somewhat objective way over the last few years of the NLRB, what we see is an activism that's got a lot of people a little bit concerned. I certainly support collective bargaining, especially in the private sector. Certainly support the rights of people to organize. But if you take a look at what's happened with the joint employer standard, where you're trying to get someone, a franchisor who's not responsible for payroll, to be part of a collective bargaining unit, strikes a lot of people as a stretch. If you look at the micro unions, when you could take it to the extreme and one person is going to be a union now in order to organize. If you take a look at the free speech concerns on these ambush election rules, if you take a look at a company, a large airline manufacturer, relocating a plant, and all of a sudden that's an unfair labor practice. And finally, of course, the reason that this activism, I suppose, on our side of the aisle anyway, is concerning or disconcerting is it had to be done, or was tried to be done, through the recess appointments, which the court had to intervene on. So I think if you look at the data and the facts, it's pretty clear there's been something going on at the board. And I would ask Mr. Larkin to perhaps comment on what might be the ultimate, if you want to call it activism or ultimate end game here, and that is the end of a secret ballot. Card check for everyone. It's very concerning to me because that is at the essence of not only our constitutional governance, but philosophically, the idea of the absence of coercion in any form of election is key. Is it not?
Yes, and prior Congresses tried and failed to amend the National Labor Relations Act to remove the secret ballot. Another thing I suppose that I could add to that comment on card check is, if you look at the joint employer standard, in addition to all of the uncertainty and confusion and chaos that's caused businesses like Ms. Alul's based on the legal standard itself, there's more going on beneath the surface of that whole debate. The new joint employer standard, in my view, has nothing to do with the facts of that case or joint employer in the temporary staffing industry. It is about a need for a change in the law on the side of organized labor to unionize from the top down in the franchising industry. We've all seen Fight for 15, and I'm not here to pass judgment on whether workers deserve $15 an hour. But what's beneath the surface of that movement is an effort to organize in retail and fast food. It's illegal under the National Labor Relations Act.
Thank you.
Go ahead.
Mr. Lajeunesse, you mentioned back in the private sector, of course, Hudson, in the public sector with regard to First Amendment rights. And I want to elaborate or get your take on that. In Minnesota, we've got personal care assistants who are having dues taken out of their paycheck, and sometimes they're not aware of it. It's certainly been a card check type method of organizing there on some of these home health care workers and that sort of thing, notwithstanding Quinn. But if you look at back in Hudson, could you elaborate a little bit on getting around that First Amendment protection with agency fees and what those levels are and what they should be?
I'm not sure I understand your question.
Well, for instance, in my home state, you don't have to join the union, obviously. You have a right to join or not join in many cases. But you do have to pay for agency costs, collective bargaining costs. The problem becomes when those collective bargaining costs become so exorbitant, being 60, 70, 80% of the dues, why not join?
Well, that's the incentive that employees have. The problem, of course, is who determines what percentage is chargeable to the objecting non-member. It's the union. Right. And the records are very complex. And the board has done a lousy job in protecting the rights of private sector employees who object to the use of their forced fees for political and other non-bargaining purposes, as I pointed out in my testimony. And the solution to that, I see, is the passage of a national right to work law, sponsored by your colleague, Mr. Wilson, from South Carolina, which would take that matter out of the hands of the board and put it in the hands of the individual employee who could decide whether he wants to voluntarily join the union or not.
I thank you for your testimony, as I do all the witnesses. I yield my back. Thank you.
I thank the gentleman. Now I recognize for 5 minutes of questioning the gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman, and thank you to all the witnesses. Ms. Alul, thank you for being here. I really appreciate the important services that you provide through your franchise. I'm familiar with the work of home care workers both in Oregon, and it's really valuable services that they're providing. And just so you know, when I was in private practice of law, I represented several franchisees. And so I'm very familiar with what a franchise agreement looks like, and I listened very carefully to your description of your work and what your franchise does and doesn't do. And it sounds to me like you are in a franchise that's much more like the Freshie case, where the franchisor is basically ensuring a standardized product and customer experience, and as you said, the technology platform, and not at all in a situation where your franchisor is really directing your employees or how you handle your employees or your scheduling. And I hope you're familiar with that franchise, the Freshie franchise case in this situation. And I also hope that, I know you mentioned uncertainty. And it seems, I don't want to give you something else to worry about, but with home care work and the important work that you do taking care of seniors and people with disabilities, it seems like you would have a lot of uncertainty about, for example, what's going to happen with Social Security and Medicare and Medicaid in this administration and this Congress, and what might happen with the tax code and lots of other things that might affect the people you take care of. So I just Not to give you something else to worry about, but I think that your franchise and this possibility, remote possibility that something like this might affect your work is not something that you should be concerned about. That's not legal advice. But Ms. Davis, I wanted to ask you, Mr. Larkin described he said this is a controversial new test. And I'm sure you're familiar with, Browning-Ferris wasn't even about franchises. In this McDonald's case, I mean, I actually have some of the transcript, and the HR director was actually assisting stores and talking to their employees, talking to them about minimum wage, identifying potential activity, talking to them about changing their store procedures, and even said, quote, this is a partnership between McDonald's and the franchisee that requires 100% support. So I know Mr. Larkin said it's a controversial new test and many business models are threatened. Doesn't seem like that to me. Would you respond to that? And then I want to ask you.
Yes, thank you very much. I completely agree with you, and I share your desire to tell Ms. Alul that as she described her franchise, where she employs, places, trains, promotes everyone, the franchisor gets involved in nothing, and you compare that with the BFI facts, where the franchisor capped wages, set schedules for overtime, set schedules for the production line, set safety schedules, met every day with the supervisors and told them what to do. Take that, combine the fact that in a footnote in BFI, they indicated that they were not taking a position on the franchisor-franchisee relationship. Fold in Freshies, which I'm going to provide you a copy afterwards because I think it will give you some comfort, where there was completely the same level of disengagement by the franchisor in the employment practices of the franchisee, and the general counsel felt there was no basis for a complaint. So I think in light of all those factors, there really is no concern that this is a radical change in the law. The law for 50 years had the common law test. That's what the board embraced here. That's what Taft-Hartley instructed the board to imply. And finally, with respect to the insecurity of what is going to happen with respect to reserved control, the board made very clear in BFI that that is a reserved contractual control.
Thank you. And I want to get in my last minute. The Murphy's Oil cases, I'm really concerned about the individual arbitration rights. And I know the circuits are split. So what would be the implications of broadly limiting a workers' collective action rights in a forum such as like a condition of employment to enter into one of these forced arbitration clauses?
Thank you. Yes. Well, the Supreme Court is going to soon let us know. I believe this October the case is going to be heard, whether Murphy Oil is going to live or die. I firmly believe that based on two essential forks of Supreme Court precedent. One is that workers have a right collectively to join together and file a lawsuit over their terms and conditions of employment. And secondly, you can't condition workers' employment on them giving up their statutory rights. And thirdly, given the collective rights that this statute protects, I think it is a well-reasoned decision that I hope will hold. We won't know that yet for a couple months.
What would be the implications to workers, though, if
I think workers will be, as I believe the statistics, over 65% of the employers require employees to sign these agreements, in which cases they will not have the right and will not be able to afford individually, in most cases, to pursue these claims on their own.
Thank you. My time has expired. I yield back. Thank you, Mr. Chairman.
Thank the gentlelady, and now I recognize the gentleman from the thumb of the great state of Michigan, Mr. Mitchell.
Thank you, Mr. Chairman. I grew up in a union household. Dad built trucks on the line for General Motors. I worked both in a union environment at Chrysler Corporation and led a company that was a non-union company. So I think my colleagues on this side of the aisle are correct. This hearing and the purpose of this committee is, in fact, to get back to what is the core mission of the NLRB. In my opinion, it's about the worker and the employer not protecting union leadership and union organizations' needs, which has evolved to in the last 8 years. Union membership, private sector union membership has gone down. It's gone down to about 6.4% of the private sector employers now in a union. And my interpretation, Mr. Larkin, is that an awful lot of these rules have been developed in one last gasp for private unions to hold on to some shred of being something beyond a public union environment. You have an opinion on that, sir?
Well, it's fairly clear to me that the rules were passed to facilitate union success in organizing campaigns. And going back to the if it ain't broke, don't fix it thought, unions were already winning 60 to 65% of representation cases. So there was no need to improve that system. The one point that I'd really like to make, if I could, because I think it's gone on long enough here today. We've talked about this Freshie memo.
I was going to ask you about that, yes.
And, you know, Freshie is a general counsel advice memorandum. It's not an administrative law judge decision. It is certainly not a decision of the full NLRB. Advice memorandum have no precedential value whatever. So that's number one. Number two is that it was issued before Browning-Ferris came out. And number three is that if that opinion in Freshie was truly what the general counsel believed, then I would question why the McDonald's case is still going on. The Freshie logic certainly hasn't caused Mr. Griffin to discontinue his pursuit of McDonald's and all of its franchisees, who I'm certain take no comfort in the Freshie memo.
Ms. Alul, I have a question for you, please. Ms. Davis has referenced multiple times anxiety. You know, don't let anxiety bother you. It shouldn't be a concern. It'll all work itself out. What does anxiety do for you and your business when you're looking to hire, expand? What does that do for you?
Thank you for your question, Congressman. Every hour I spend not working on my business is an hour I'm spending on regulatory issues. That does provoke anxiety. It slows my hiring. It slows my ability to serve customers. It slows my ability to run a much more efficient business. In a small business, I am the most expensive resource in that business. So every hour I spend talking to you about that is a pleasure of mine, obviously, but is an hour I'm not spending on my business, sir. Nobody in this room, nobody at all, is able to safely assure me that a standard based on indirect, reserved, unexercised, direct, indirect, what have you, control is never going to get me. You can't assure me that. I wish you can, but you cannot. And that is anxiety-provoking, sir, and it affects my ability to run a business. I'm not the only one. I know you know the numbers. Everybody likes statistics. My background is in economics, and I'd love to share a few numbers with you as well. There are 7.6 million employees in the United States under a franchise agreement, one way or another. It generates over around $700 billion of economic activities. That's 2.5% of our GDP. It's 700,000 businesses like mine that are telling you this is affecting my ability to run my business. This has to be heard. Like, you can't just assume, leave it alone, it'll run away, it'll go away on its own. It won't.
Thank you. Thank you. I'll close with this, Ms. Davis. It's not code. There's no code, in my opinion, what we're doing here in the committee. It's clear to go back to the worker and employer relationship, not simply protect the union hierarchy. And anxiety kills jobs. It kills jobs in this country, and I work hard in this committee to ensure that we fix that problem now and going forward. Thank you. I yield back.
I thank the gentleman. I recognize the gentlelady from New Hampshire, a fellow 2006 classmate of mine. Welcome to the committee.
Thank you, and it's good to be back here. I spent 4 years on this committee, and I certainly heard a lot of the debate, and it's interesting to me that this is ramped up again, and I'm sorry that it is, because I might be, and forgive me if some of you also had this experience, but I might be the only person here on this committee who actually worked in a non-union factory when I was putting myself through college and watched what would happen because they were trying to unionize at the time, and I saw some pretty awful things to prevent that. And I know that none of you would agree with this, but I saw things such as a woman who fainted on the line. She was pregnant, and the foreman came over and said to her, you know, to go to the nurse's office, and on the way, pick up your check, you're done. And that, we must remember, still happens. Happened then, happens now. So as we talk about this, we need to remember that we're talking about people, we're talking about workers. We're talking about a lot of workers who are earning a wage that none of us would accept. We're talking about a minimum wage, which is impossible to live on, and then we're talking about that too. So while we're here and we're airing all of this, I ask people on this committee to remember that we have real people's lives at stake here. And I heard your testimony on your small business, and My mother was a small business owner. I do recognize and understand the challenges there as well. But we are talking about people who don't have opportunity and don't have people to defend them in these settings and nowhere to go, and you can't feel safe because you could lose your job. And ultimately, I hope that that's what we think about those workers. So, Ms. Davis, my question to you is, we're having a bitter fight in New Hampshire about right-to-work laws, and Republicans and Democrats are working together to try to protect unions in New Hampshire. Are workers' wages and benefits better or worse in states that have right-to-work laws?
So there's a lot of statistics on this. In right-to-work states, the workers make on average $6,000 less than in non-right-to-work states, which is about 12% per worker. So it's a significant difference. And then when you add on the pension statistics, where 75% of the workers in right-to-work states have no pension, as compared to 15% in non-right-to-work states. Health care, 80% versus 50%. And to address one of the issues you addressed initially, which is health and safety, the fatalities in right-to-work states are 50% higher than in non-right-to-work states. We're now in New York City seeing in non-union construction jobs the fatalities so high that legislation is being considered as compared to unionized jobs. So I think that collectively as a fabric, there's an enormous difference in terms of the issue you raised: worker well-being, worker safety, worker health.
Okay, and then the other question is, what is the impact of right-to-work laws on job creation? Because I know they debate, and I know there are statistics, but I'd like you to share them, that if you are in a state that has right-to-work laws versus there's going to be a difference in job creation. So would you address that, please?
Right. I think the statistics are unassailable that the job creation in right-to-work states is not at all better than in non-right-to-work states. We have a serious problem in this country, whether it's globalization, whether it's technology increasing, that there are fundamentally not the same kinds of good middle-class jobs that existed 50 years ago. But as we learned when trickle-down economics failed, the solution to that is not to bust unions. The solution to that is to try to, as the statute itself was designed to do, create a strong economy, build a middle class as a result of employees having the choice to join a union.
Right, and then I have one last thing. Is there anything, I've got about 45 seconds, any last thought you'd like to share that we didn't ask you yet, but you want us to know?
Well, that's a tough one. I think there's a fundamental question of what the role of Congress is and what the role of the board is. And if we look back at the statute itself, Congress intended this act to be administered by an agency that had expertise. It envisioned that it would change as administrations changed and its terms were staggered. So I think we need to let this process run. We need to let the board do what it is supposed to do, which is set labor policy, and let Congress do the important things that it's supposed to do. The one final thing I wanted to say about the right-to-work law is that we hear a lot from the Republicans about giving control to the states, and that's what Congress did in the NLRA. It gave right-to-work decisions to the states. I think it is wrong-headed to now take that away.
Thank you, and thank you to all the panelists for being here today, and I yield back.
I thank the gentlelady, and now I recognize the gentleman from Georgia, Mr. Ferguson.
Thank you, Mr. Chairman. Ms. Davis, I believe I heard you open with the statement that the changes to the NRLB were modest.
If you're talking about the election rule changes, that's correct.
Okay, thank you. Ms. Alul, I want to thank you for your testimony as well. Mr. Mitchell from Michigan touched on a couple of things there about anxiety and what you think about on a daily basis there, and I am certainly empathetic to your position. I've run a small business in my district for 25 years. And certainly understand the uncertainty that occurs when small businesses are faced with those real challenges. I don't think it's appropriate for members of this committee to tell you what you should be worried about. You experience it absolutely every single day, so I will try to avoid doing that as well. So Mr. Larkin, the question I have for you, do you mind briefly describing the changes in the Taft-Hartley law defining regarding how the employer-employee relationship is defined and what the congressional intent was of that law, of those changes.
Sure. If you're referring specifically to specialty health care, I can read you from the original Wagner Act that Senator Biddle, when the debate was about who should have the power to decide what is the appropriate bargaining unit, said that to lodge the power of determining this question with the employer would invite unlimited abuse and gerrymandering the units. But if the employees themselves could make the decision without proper consideration of the elements which should constitute the appropriate units, they could, in any given instance, defeat the practical significance of a majority rule, and by breaking off into small groups could make it impossible for the employer to run his plan. That's from the original Wagner Act. And in 1947, when they passed the Taft-Hartley amendments to the Act, the legislative history states that the prescription in Section 9C5 that says that the extent of union organization cannot control the outcome of a bargaining unit determination, that was passed to strike at the practice of the board by which it's set up as units appropriate for bargaining whatever group or groups the petitioning union has organized at the time. That's the history of the National Labor Relations Act, and that's what, in my view, the specialty health care rule simply departs from. And
So, Mr. Larkin, when there's that large of departure, would you say that the NRLB directly subverted the legislative process in making its new rules?
Well, an argument that employers have made, and that I've certainly made in cases involving specialty health care challenges, is that the board did go beyond its statutory mandate and that the rule as it is written violates what I just read to you.
So anytime that you have an administrative body of people that were either appointed or hired making major changes to the rules, I certainly wouldn't call those changes modest. Would you?
No.
Okay, thank you, sir. Mr. Longinus, if you could, I want to give you an opportunity to respond very quickly to some of the comments regarding right-to-work states versus union states. I'm from Georgia. It's a right-to-work state. We have seen tremendous job growth. If you could give me your thoughts on that, but also on how and again, I'm not trying to argue for unions or against unions, but just could you give some background and some facts to that and give your perspective on it?
Sure. Well, I'm a lawyer, not an economist or a statistician, so I'm not an expert on some of the subjects, the numbers. You can find statistics to prove anything. But if you look at statistics adjusting wages for cost of living, wages are higher in right-to-work states, not lower. The suggestion that a law which allows an individual worker to decide voluntarily whether to financially support a union or not causes higher rates of fatalities, that's ridiculous. I think the short answer to the issue of statistics is go to the website of the National Institute of Labor Relations and Research, which collects the studies on this subject, which rebuts all of the arguments that Ms. Davis has made.
Thank you, Mr. Chairman. I yield back.
I thank the gentleman. I recognize the gentlelady from the great state of Ohio, Ms. Fudge.
Thank you so much, Mr. Chairman and Mr. Sablon. Thank you all for being here today. I've been on this committee for almost 10 years. This is the 25th hearing and/or markup we have had on the same exact subject. I'm happy that all of you agree that we should have a full complement of members on the NLRB. President Barack Obama tried to do that, and my colleagues on the other side of the aisle blocked him. So I'm happy that you think that that was a good thing. This really is, to be honest, nothing more than a continued attack on unions. It is an attempt to eviscerate all worker rights and to give all rights and all power to employers. In a few minutes, we'll look around and somebody will be saying that we should do away with the minimum wage. Let's just pay people what the market can bear. They'll say we should have no more paid leave, whether it be sick leave, vacation, whatever, things that have been gained through unions. It's interesting.
that we continue to just go around and around and around about this. I just want us to understand what's happening here. This is not something new. This is something that has been a part of this committee's agenda for a long time. I wish they would just come out and say it. Ms. Davis, the gentleman sitting next to you said that you can find statistics on anything. Sir, I would hope that you'd send me whatever those statistics are that you have. Ms. Davis, we have been talking about right-to-work states. Let's just tell me again how you know for a fact that right-to-work states do not protect employers, do not make their lives better, do not protect them in any way, really. The floor is yours, Ms. Davis.
Thank you very much. And I do want to distinguish to the gentleman on my physical left that there is a difference between opinion, and I have expressed opinion at times, and statistics and facts, which I have also given you. I'm happy, I have a pile of papers here, I'm happy to provide them. The statistics on income, pension, health, safety in right-to-work states is data. It is not opinion. So I think that whether or not it is a philosophical question, whether or not you want to make it harder for employees to choose to have a union in their workplace. But there is no question whatever in states that make it virtually impossible or extremely difficult, which is right-to-work states, the data on employee well-being, health, safety, wages is unassailable.
And you talked about the fact that income inequality is at an all-time high. And I'm assuming, and you can correct me if I'm wrong, that it is high because union membership is declining.
That's correct. And there are visual, and I actually think the government puts these out, there are visual graphs that you can see that tracks union density from 1963 to the present and tracks income during that period. And there's an absolute congruity between union density, creating higher wages, and union decline, which we have had essentially since the early 80s in the air traffic controller's debacle, leading to declined wages. There's no question that when employees have a collective voice in their workplace and they're not subject to being fired at whim, they are able to negotiate better terms and conditions that at the end of the day help everyone.
Thank you. And since our job really is the Labor Relations Act and not to tell the board how to conduct themselves, is there anything that you think we can do on our side to make the act better?
Well, we had that aspiration in the 90s, and that didn't work out. So I think at this point, given the political realities, that there's nothing that can be done to amend the act. I actually did testify here during the recess appointment issue. Supreme Court disagreed with my view that it was constitutional, but I think there is no question that the president was blocked in putting people on the board and letting the agency do its work. And a lot of the partisanships that we've seen have directly been attributable to the partisanship in the Senate that have prevented the board appointees from doing their work. So I think that allowing the board to function, even in this new administration, it's not going to be something that I'm going to believe in most part, but I think we need to let the agency do its work as it has done for 80 years.
Thank you very, very much. I thank you all. Mr. Chairman, I yield back.
I thank the gentlelady. Now I recognize the gentleman from Georgia, Mr. Allen.
Thank you, Mr. Chairman. And, you know, for the last 2 years, well, 2.5 years ago, I was out in the working world and as a small business owner. And, of course, for the last 2 years, I've heard all the arguments one way or the other about a lot of this rulemaking, and frankly, being in a relationship with my employers, some of these things really were disturbing to me because it seemed like it was pitting the employer against the employee, and you know, we just don't have that relationship in our company. And real quickly, a story of that is a young man that's been with our company for 40 years, and he was the second person I hired, and his sister needed a kidney transplant, and he was the match, and he was going to be out of work for 6 weeks, and we paid him the entire time that he was out of work, and I think if he had belonged to the union, he would not have been paid. And so, you know, we don't hear stories like that too often. And so, you know, there are certainly pluses and minuses to this control factor. But, and then again, I do have a lot of experience with cost of living. I moved from Georgia, Augusta, to Washington. I live here 36 weeks a year, and I will assure you it costs about twice as much to live in Washington as it does in Augusta, Georgia. And so I felt that pressure. But so here we are as a nation, and we have right-to-work states, and we have states that are grappling with, you know, how to compete. We have in Georgia had a surge of growth in a diverse business climate, and again, it's all about the reason a business locates to a state is a skilled workforce. I mean, that is number one. Obviously, other things come into fact, but number one is skilled workforce. Mr. Larkin, in your opinion, from the standpoint of what we've seen as far as rulemaking, what has that done to contribute to the number one factor, and that's to present an educated, skilled workforce out there for all Americans?
Are you referring specifically to the election rules or to the?
Well, you know, all of these rules that come down create some problem, you know, in the system. And again, our goal is to get Americans back to work in this country. We've got, some say, 20 million people that really want to go to work that can't go to work right now. And so are there rules that we experienced over the last couple of years in your experience that are keeping us from growing our businesses and employing more people?
Well, I think the answer to that is yes. And to go back to the joint employer question, I know a tremendous concern articulated in the franchising community is that the entire franchise model is set up to be a symbiotic relationship between the small business owner and the large brand. And the large brand gets to spread its brand, and the small business owner gets to be a business owner. And if the joint employer standard is going to threaten that relationship, and I think Ms. Alul mentioned this earlier, that her franchisor is worried about all this. One of the things it could decide to do is not franchise anymore. And you know, that would be devastating to small business owners and to job growth.
Well, Ms. Alul, as far as your business is concerned, when the government, this kind of top-down, one-size-fits-all approach, whether it be healthcare related or in this case rules as far as you know, how folks organize, again, you said you have the anxiety factor, but could you, knowing that you know, you were not going to be affected by this process, I mean, would it be easier for you to grow your business, employ more people?
Absolutely. And to make this more relevant for congressmen, it's not just me. You need to multiply that by hundreds of thousands of businesses. If I'm able to hire 10 more people or 20 more people this year, multiply that by 1 million other small businesses. So answer is yes, but please don't see it as a small unit. You have to see it as the magnitude, like small businesses are the engine for growing an economy. We go around the world teaching people that, teaching countries that. It's the small businesses that create jobs and create economic output. So answer is definitely yes, sir.
Well, thank you. Thank you for that answer.
Gentleman's time has expired. Thank you. And now I recognize the gentleman from New York, new member of our committee, Mr. Espaillat.
Thank you, Mr. Chairman, and thanks to all the witnesses for their lending testimonies. I have to concur with my colleague and her previous characterization that this is the 25th hearing on the National Labor Relations Board since the Republicans took control of Congress in 2011. And this hearing makes it clear that part of the majority's agenda will focus on weakening private sector unions, which only make up 7% of the workforce. And, something was mentioned about the fast food industry and how franchises there, which employ obviously millions of Americans, are faring off. Now, I happen to think that many of these fast food franchises keep their workers under the minimum wage, and by doing so, these workers fall under the poverty levels in many of the states across the union, and are then eligible for things like food stamps, Section 8, other types of benefits that are paid by the American taxpayer. And so this is concerning, particularly since the nominee for Secretary of Labor is the owner of one of these fast food franchises. And I just want, Ms. Davis, for you to elaborate a little bit more about, I know that we've already gone through the discussion of whether right-to-work states have better incomes or not. I think the big elephant in the room is this income inequality across the nation. If we have impressive job growth in the last 8 years, although some folks would like not to admit that, what is it that's happening across the nation where the 1% keeps on growing, and then there is a good sector of the population that continues to be having a hard time making ends meet, and in particular with the fast food industry? What is it that they're doing that they're keeping these workers on the minimum wage levels and are reaping the benefits from the American taxpayers? Do you have any information about that, considering that the Secretary of Labor nominee is an owner of one of these businesses?
Thank you, fellow New Yorker. Yes, a number of us find it very disheartening that the nominee for the Secretary of Labor has come out publicly against an increase in the minimum wage, against the notion of a living wage. I think what we have seen across this country in the last couple years is an explosion of local initiatives, quite frankly, some of them outside of the labor movement, that have demanded a living wage, given the fact that workers in the fast food industry and in other industries cannot support a family even on 2 jobs. And so what we've seen, and it's quite heartening, are local ordinances everywhere from New York to Seattle that are imposing a living wage, that are requiring sick leave for employees. And I wish Mr. Allen's view on sick leave was shared by the rest of the non-union workplace, because it is an aberration to be providing sick leave in the non-union workplace. It is a hallmark of unionized workers, and it's something that we're seeing in local governments now in New York City itself, because there is such a need for protection. I think that the American people, what we've seen and what I hope we will continue to see, is a cry that the level of income equality that exists now, and quite frankly that is going to be worsened under some of the tax proposals that we've seen, is not acceptable to a nation like ours.
Yes, I just wanted to add, thank God we have the $15 an hour minimum wage coming into New York next year. I just can't imagine how someone can live on $7.25 an hour in New York, or even here in Washington, D.C. And so these folks will be forced to go to other states, and we may be continuing to lose, when the next census hits, continuing to lose some seats in our state that will go to other states. Maybe that's why this is being done this way. But I want to thank you for your information. I think income inequality continues to be the big elephant in the room, and these fast food restaurants and their practices should be under greater scrutiny. Perhaps that is why the nominee is facing some issues with the votes on the other side, on the other house.
In the 10 seconds left, I would like to remind us that McDonald's had on its website a recipe for employees to exist that included holding 2 jobs, McDonald's and another, and imposing further safety net burdens on our hospitals, which have to take patients.
Thank you.
Thank you.
Yield back my time.
I thank the gentleman, and I recognize the gentleman from Pennsylvania, Mr. Smucker.
Thank you, Mr. Chairman. Ms. Davis, just like to get your perspective. It's been mentioned frequently here today by many members, the declining union representation in our private sector workforce. What percentage is that today?
I think it's 6.4% right now in the private sector.
And could you give a sense of how that has changed over the past few decades?
So I think that at its height, union density was over 30%. When I first started practicing 35 years ago, it was about 12, 13%, and it has continued to decline.
So no one disputes that we've seen a decline regardless of any changes that have been made by the NLRB. Why do you think that is occurring, Ms. Davis?
Well, I wish I could be the expert on this, but I think there are various reasons that experts have looked at. One is globalization. The other is an increase in technology. I would suggest additionally that under the NLRA, as it has been interpreted, and quite frankly until recently, any employer that wanted to defeat unionization through practices that the board had considered legal had a very, very good shot of doing so. Any employer that wanted to defeat unionization by delaying the election and having an anti-union campaign for 3 months could do so. So I think it's a convergence of a variety of factors. Some within our control, some not.
Do you think it has anything to do with the changing relationship between employers and their employees?
Well, I think that there's not a homogeneous answer to that. I think there have been some enlightened employers in various industries, including the technology industry, where there's no density or virtually no density.
I can tell you my own experience. I've operated a small business in the construction industry, and we essentially built a business from just 1 or 2 employees to one employing over 200 individuals over a period of 25 years. The biggest problem we always faced in the growth of our business was finding enough qualified people to fill the spaces that we had available. Businesses facing that situation are required, whether they want to or not, to do everything they can to create a great workplace for their employees. And of the 200 employees that we had, they had the ability to grow in their positions. They had the ability to receive training, to increase their pay, and they were family-sustaining jobs, and we saw them as family. I believe that just the demographics that we have dramatically changed the relationship between employers. Employers today know that if they want to keep employees and hire the best, they're going to have to create great places to work, create places where people can earn the money to support their families, and they do so. And so we see a lot of new innovations today. We see employee ownership models. We see profit-sharing models. Our goal always was we were what we consider an open book company where we believe that the success of the organization, if we succeeded together, everyone should benefit accordingly. And we were one of those companies that was targeted for unionization, and we went through a number of campaigns. And our employees overwhelmingly believe that they have better opportunities through our organization. So, I'll just submit that I believe that what you're seeing today, I believe my own view is there has been unions have been a necessary part of our history, and even today, unions are necessary. But the fact of the matter is, the employer-employee relationship has changed dramatically, and today, 94% of our employees in the private sector choose to be in a non-unionized workplace.
So I'm an old Pittsburgh Pirates fan, so you should credit what I say.
Yes.
I represent unions and the construction workers in New York. Unionized workforce, extremely well-paid, benefits, the kind of situation you're describing. The non-unionized construction industry in New York has barely minimum wage industry and has had so many fatalities that the city council is now holding hearings on this. I wish all employers were like you. Unfortunately, they're not.
So I have been part of the construction industry, and I know that even non-unionized employers, safety, health of our employees is #1 priority, and we treat our employees as family. Again, I'm not one that's philosophically opposed to unions, and I see my time has
Gentleman's time has
expired.
expired.
Thank you, Mr. Chairman.
Thank you. I recognize now the ranking member of the full committee, Mr. Scott.
Thank you, Mr. Chairman. Mr. Larkin, you had a back and forth about the vacancies on the NLRB. Isn't it true that the 3 existing members have the full authority to make legal binding decisions?
They do, but it's been a long tradition at the NLRB that this isn't necessarily written anywhere in the statute, but that the board won't overrule precedent without 3 members. So there's only 3 members, so they cannot make any significant changes in the law right now unless all 3 of them agree.
Well, they can make legal decisions. I mean, the fact that there are vacancies, I didn't hear a lot of complaints about that last year, or a vacancy in the Supreme Court for that matter. But the board can make legally binding decisions. Ms. Davis, we've heard a lot about the joint employer, and did you make a comment about whether or not there's any ambiguity about Mrs. Alul's case?
Well, first of all, I mean,
the way she described it.
Yes. First of all, there is, because this is a board that issues decisions when cases come to it, there is always an interpretive exercise as each case comes to it. And the joint employer decision, the joint employer analysis is a very fact-driven analysis, like so many others. So there is not, and there will not be, and there has not been, since the act was passed, a rule that we could look at on that, on handbooks, were mentioned earlier, policies, that tells us exactly what is what. But what we can do, what businesses can do, is look at the decision and analyze it and decide whether or not there is risk. We do that all the time in every area of the law. And I suggest if you look at the BFI decision, it's very, very, very fact-specific. It gives us guidance that franchisees, franchisors can rely on.
Based on her description and the BFI and the Freshie case, is there any question in your mind that that would not be a joint employer situation?
Well, I'm not going to be rendering legal advice to Ms. Alul, but I think that if you take the factors she listed about her control over her workforce and you contrast that with the factors in BFI, which I discussed earlier, there seems to be no congruity between the BFI joint employer decision and Ms. Alul's situation.
What kind of control did BFI have over their employees?
BFI had both reserved contractual control and actual control over the leased employees. It was not a franchiser situation. Most importantly, it had a salary cap for our purposes, which precluded the supplier-employer from setting wages higher than a certain level, which is distinct from Ms. Alul's situation.
Now, what kind of problems occur when you have a joint employer situation, but the joint employer, the franchisor, is not at the table?
So if indeed there is the control over labor relation decisions, as we believe there is in McDonald's, based on the evidence that's come out so far, and the franchisor in that case is taken off the hook, if the employees opt to be represented by a union, the union will not be able to bargain with the party that's actually setting the terms and conditions of employment. It's an untenable situation.
If you, in a right-to-work state, what benefits do non-union members get compared to the benefits of dues-paying members?
So they get safety net benefits in a right-to-work state, but other than that, there's no guarantee of sick pay, holiday pay, above minimum wage conditions, vacation pay.
If they belong to a union,
if
they belong to a union and the union has negotiated a contract, what benefits of that contract does a person who didn't pay any dues, what benefits do they get?
The person who pays no dues gets precisely the same benefits as the union members get under the contract. That's the law.
So if the union raised money from its members, negotiated a contract, then people who didn't pay any dues get the same benefits?
That's correct.
when can relocating a plant constitute an unfair labor practice?
Only when it's found to be retaliatory, which was the case in the Boeing complaint. The relocation in and of itself is totally lawful.
Thank you, Mr. Chairman.
Thank you.
I thank the gentleman, and I recognize the gentleman from Indiana, Mr. Rakita.
I thank the chairman. Good morning and welcome to everyone. I appreciate the witness testimony. I want to begin my questioning to Mr. Larkin, but first I want to thank Chairman Wahlberg for holding this hearing, and let me say it's great to be on the HELP subcommittee again, so thanks for having me. Mr. Larkin, did you have any response to Ms. Davis's answers in the last line of questioning regarding right to work, regarding joint employer standards, anything like that? Anything you want to add or contrast?
Sure, I would. Well, I would defer discussion about right to work to Mr. LaJeunesse, who is the expert on the panel on that. You know, I did want to make a few points about the specialty healthcare standard, because there were some points raised and a particular case raised. And what I heard was statistics about the size of the bargaining unit, and that since the specialty healthcare decisions, the bargaining unit size hasn't gotten smaller. When we use the phrase micro unit, it has nothing to do with the number of employees in the unit. It's about the size of the unit in relation to the rest of the employer's workforce. And the reason that specialty healthcare sets up the potential for micro units is that it allows a union to fragment an employer's workforce into artificial segments that don't bear any rational relation to the employer's actual business. A case that I would mention to you on that is the Yale University case that just came out 2 weeks ago. The union petitioned for 9 separate collective bargaining units, each one of 9 separate academic departments at Yale University, and the regional director in that case approved that under specialty. So they're going to go to 9 elections, 1 in each department. And so think about how Yale University is going to bargain with the union over 9 separate bargaining units, all of whom are academic faculty, meaningfully and effectively. That's the problem, we think, with the specialty rule. It allows that kind of result, and that just can't be the right answer under the Act.
Well, is it in fact not it's not the answer they want? They just want to, in effect, give up then and just have a blanket union covering everybody in some kind of negotiation, right? I mean, wouldn't that be the next logical step? Yes, you can't manage 9 different elections, so we're just going to go ahead and submit to whatever ultimately the union wants.
I don't know what the union in that case is thinking, but that's certainly
possible.
Possible, yes.
Talk to me about Browning Ferris Industries, that NLRB 3-2 decision revising the joint employer standard.
Well, there's been quite a lot of discussion about Browning Ferris today on both sides. You know, I think we've heard from Ms. Alul about what that standard's done to the certainty with her relationship.
Why do you think the General Counsel chose to pursue that standard, NLRB Counsel?
Well, I mentioned this earlier, but I think that it has a lot to do with the organizing desires of labor and their desire to organize more easily in franchising. And this standard clearly allows that. And it's no coincidence, I would suggest, that the very first target the General Counsel picked after Browning Ferris came out was McDonald's.
Right. And switching to you, Mr. LaJeunesse, feel free to comment on right to work if you'd like, but I have a particular question for you.
Sure.
You have practiced at the NLRB for a long time. Over the last 8 years, how has it been different from other times in your career?
Well, it's more difficult for non-union employees who bring charges against unions for violation of the Act to get complaints issued by the General Counsel. And the board, as I pointed out in my testimony, has failed to fully enforce the right of workers to refrain from supporting unions financially and to refrain from union representation.
But sir, couldn't you argue that this is just a case of the pendulum swinging from a Democratic flavor to a Republican and back and forth? Or is there something, did you notice something inherently different about the Obama-era NLRB versus other Democratic administrations?
Well, it's swung a lot farther
Left?
this time than ever before.
Farther left?
Farther pro-union, whether you want to call that left or not. Is, if I may comment on the right-to-work situation that
about 10 seconds.
Congressman Scott addressed. The employee in a right-to-work state who's in a unionized shop is stuck with whatever the union negotiates. He cannot negotiate his own terms and conditions of employment, even if he thinks he deserves more than the one-size-fits-all contract. And he can't work out his own grievances with the employer without the union's approval.
I thank the gentleman. Time has expired. Thanks for staying around to the very end and coming back after a busy chairmanship yourself. So, before we go to closing comments, I ask unanimous consent to submit for the record the following two letters. One, a letter from the Coalition for a Democratic Workforce regarding recent actions by the NLRB, and two, a letter from the Retail Industry Leaders Association, also regarding recent actions by the NLRB. Hearing no objection, the letters are submitted. This time, I now recognize the ranking member for closing comments.
All right. Thank you. Thank you, Mr. Chairman, for holding this hearing. And today we've heard how the National Labor Relations Board has adhered to historic precedent and how it has facilitated the core process of the National Labor Relations Act through its election rule. As an indicator that the decisions of the NLRB are squarely within the mainstream, the board's decisions have been consistently upheld by the Court of Appeals. In the last 5 years alone, there were 284 appeals to the courts, and they were sustained 233 times. This includes the specialty healthcare case, which has been upheld in 7 Court of Appeals. But it is troubling that there are efforts underway to undermine workers' efforts to organize and to weaken labor unions. This includes right-to-work legislation, which is falsely promoted as promoting economic development. Mr. Chairman, we have letters from the International Brotherhood of Teamsters, the United Steelworkers, and the International Associations of Fire Workers opposing right-to-work legislation introduced this Congress. I ask that it be inserted in the record.
Hearing no objection, it will be inserted.
All right. Let me quote from the Teamsters letter. I quote, 9 of the 10 states with the highest poverty rates are right-to-work states. Workers in states with right-to-work laws make about $1,500 less per year than workers in free bargaining states. Workers in right-to-work states are less likely to have employer-paid health care and pensions and more likely to die in accidents on the job. Right to work does the opposite of empowering workers. It weakens their ability to bargain collectively to build a future for their families. Mr. Chairman, I would like that these letters be entered to the record. I have already asked that. I also would like to thank all the witnesses I know you had spent time preparing for today's hearing. We don't have to agree with one another, but I appreciate the effort you have done to prepare and also for coming and sharing your thoughts with us today. Thank you very much for doing that. And I yield back. Thank you.
I thank the gentleman, and I would concur. Thank you to the panel for being here today. It would be a rather unproductive hearing without you, and so appreciate you being here. Also appreciation, though most have left now, except you and me, to the great attendance from both sides of the aisle for this hearing. Let me say this as a former United Steelworker myself. Going back to the last time that I paid union dues, as a union steel worker at Southworks U.S. Steel, south side of Chicago. I certainly would indicate that the working conditions that I see now as I walk through steel plants in my district and other places are far superior to what I experienced back in 1969, 70. And that's a good thing for safety, et cetera, that goes on. But I also know that there are 28 states in the Union that now are right-to-work states. My own state of Michigan as well. And while I hear statistics and figures and assertions thrown all over the place, I have to say, at the very least, that being the case, 28 states in the Union being right-to-work states, individual workers having the opportunity to choose to be in a union or not. The decrease in the numbers in the unions right now indicate to me that it's not because these workers now want to work in worse situations, be paid less, have inferior benefits, that they're choosing to be in these states and these workplaces. Our concern today, and why we've had over the course of the past 6 years, 25 if that is the number, hearings on NLRB, is because the major impact that NLRB has on the workplace, and a concern that we are putting a thumb on the scales, especially in these last 8 years, to try to stop that slide of union involvement. As I said, I appreciate what I see when I walk through steel mills now, that I don't see workers doing some of the things that I had to do, had no choice. That was the working situation. That isn't the case now. So I'd submit to you that we may have other hearings on the NLRB. We want to get things right. We've got a lot of issues to address. We want to make sure that the workplace moves forward, that it's sustainable, that it expands. Why? So that we have more workers capable of being in a job that's secure, that gives them choices for the future to grow, and that we have needs met of constituents for their economic impact as well, and in this case with Ms. Alul, the opportunity to have care given in difficult stages of their life, and that we don't have unnecessary bureaucracy, rules, and regs standing in the way. I would suggest to you that there is a reason why the NLRB is pushing to put arbitrary and artificial roadblocks and standards in the way, to put the thumb on the scale, to assist in stopping the slide in the growth of unions, and to turn that around without the request of the employee themselves. We see at this point in time almost $2 trillion of regulatory compliance costs that are on the backs of job providers. When we see the increased costs to not only the job providers but to the employees because of the Affordable Care Act and its taxes, its mandates, its work hour requirement, et cetera. Those are problems that are frustrating the growth in our economy, and those are things we need to deal with. So while I know there's a difference of opinion, there are, I hope, not two parallel universes, but sometimes it appears that to be the case. I would hope that we could come together and work to make sure that employees and employers benefit in the coming days, months, and years, as opposed to being in a combative relationship that does no good for either side. And we'll do our best in this committee to achieve that. Having said that, and having no other business to come before the committee stands adjourned.